I'm Fred Gray, and I would like to say thank you for joining us today. This is our second roundtable that we've done. We call it the gray area for some reason. I'm not sure why, but we have roundtable discussions. I'm president of Gray Systems Incorporated, which is a provider of the pre-licensure course for community association managers. We also do continuing education, which we've been doing since 1989 throughout the state. We've watched the growth of the profession, participated in it on both the legislative side and the practical side as well. And we've enjoyed many of you attending our classes in the past. I saw the registration list and a lot of names I recognize on there as well. And you're all welcome. And we're going to make this as quick, as interactive as we can and try to participate. And I'm not going to take a lot of time on myself. I would like to introduce Mr. Spencer Hennings, who is the Ombudsman appointed by the governor in July of 2020. And I'm going to let him tell you a little bit about himself, his background. Also, he's going to explain what the Ombudsman's office does and duties and resources available to the condominium world. And I do like to emphasize this is for condominiums only. The Ombudsman's office is not empowered to interact or provide guidance or advice to cooperatives or homeowners associations as well. So with that, I'd like to turn it over to Mr. Hennings and say thank you for being with us today. And glad to have you here. And hopefully we'll have a good time.
Thank you for the introduction. Good afternoon, everyone. My name is Spencer Hennings. I'm the Condominium Ombudsman for the state of Florida. And thank you to Gray Systems for inviting me on here. You know, I'm trying to make myself and my office as available and accessible as possible for the condo owners and board members and managers and attorneys specializing in condo law throughout the state. So I'm really excited and happy to be here participating in this event and events like it. I'd like to just take a second to go over the services and resources that my office does offer. I think there's, it's a bit of a gray area, if you will, at this point. People don't really know. So the first thing that I'll say is that the office was created with the intent of being an educational resource. A big goal of mine is working on an educational curriculum that will start out as webinars during the age of COVID. And it will have a curriculum that encompasses unit owner rights and responsibilities and board member rights and responsibilities, so that the goal is if people are educated on these topics, we can prevent issues from arising before they arise. And I think that's obviously preferable to rather having to run around and fix issues afterwards through the complaint process or through arbitration or litigation. Aside from that, we do dispute resolution. So in this capacity, I function as a neutral mediator, you could say. And I don't have the authority to hand down legal holdings. I can't take the place of an arbitrator or a judge, but oftentimes issues can be resolved by just a couple meetings or a couple phone calls or emails. And I'm happy to do that. I do that hours every single day. I'm on the phone with attorneys and managers and board members and unit owners trying to work out creative solutions for everyday problems that do arise in condominiums throughout the state. The next capacity, the next resource we offer rather, is election monitoring. We're probably most well known for this, and it's an amazing resource. Basically, we appoint a neutral, independent, and experienced person that has conducted countless condo elections, such as Diana, who's on the webinar today, to go out to your condominium and completely conduct the election from start to end. The election monitor can receive the ballots directly from unit owners. The election monitor will open the envelopes, verify the names, verify the voting certificates, tally the ballots, and announce the winner. And I can promise you, if you do have an election monitor present at your election, it will be a fair one. So this is a great resource. And I'm of the opinion that unit owners don't have much power, unfortunately, in their associations aside from voting for their board. So I take this really seriously, and elections are of utmost importance to me in my office. The last thing I'll say that we do, or that I do rather, is I'm responsible to make legislative recommendations to the legislature and also policy recommendations to the governor's office having to do with condominium law and policy. So this is something that I'm working on, and I have a list that is being modified, and I enjoy speaking with people from all different sides of the spectrum and hearing different perspectives on what could be changed to make life better for our unit owners and board members throughout the state.
Thank you, Spencer. It's nice to know that. One of the things you mentioned there that I'm happy to see is you're making yourself much more visible to the community than we've had some of the ombudsman appointees in the past. And I think it's a great resource for all the community associations, all the questions we get. I'm going to go through some of the questions that we received earlier. We have some really good questions here.
Okay.
Some of them I'm going to tie into one question rather than they've asked a lot of them in different ways here as well. And I think Mr. Hennings also opened up there with his duties and responsibilities are spelled out to some extent in the statute, in the Condominium Act. I'm not sure, but somebody asked, is there anything in the Florida Administrative Code that addresses your office as well?
There is. So in the Condominium Act 718, I would suggest if you're curious, you can look at 718-5012, which talks about the ombudsman's duties and powers and responsibilities. And in the Florida Administrative Code, I would look at Rule 61B-23. And there's a lot of information on how associations need to be run. And there's also information on my role in elections and various other topics.
I want to address one issue that's been throughout the questions we have here, and that is, what is the board's power, duty, authority, responsibility to mandate or not mandate mask, social distancing, sanitizing throughout the community, the common areas, whatever like that. We had many discussions about this, but we'd like to hear in summary what your thoughts are in that area.
Sure. So the first thing I'll say is that the state does not mandate that associations create rules around masks or sanitary stations or pass rules and regulations differently than what they've already done. I think this is a case by case basis approach. And I think that the board needs to sit down with the manager and the attorney for that association and discuss, based on the size and the amount of units and the type of people that live there and what the people want, how they're going to protect those unit owners and the renters and everyone else on the property, because they do, in fact, have a duty to do that.
Good answer, I believe, because there is no answer to that question overall. It's coming back to the individual issues as well. Can you talk briefly about the relationship or the positions of the officers and the board members in a condominium, how they're selected and what their powers and duties are? One question I get quite often is, can one person hold more than one office? And is there any limit on, for example, the president can't be the secretary as well or something like that? Is there any comments you have in that area?
Yeah, a lot of this will be answered in the specific governing documents. And that's really what I would point to. It could be different from association to association. As far as the board members, this is the most, statutory guidelined part of running the association, right? There are noticing requirements, there are balloting requirements, and you cannot vote by proxy. We have electronic voting now, but the voting of the directors is what the unit owners do. The election of officers is usually done by the board themselves.
Well, I'm going to summarize another question that I've put together here from all of these questions, and that is, can you address the concept of holding board meetings and membership meetings in the time of the COVID issue, and what is allowed or is not allowed, what the statute does provide or does not address as well. So that can say a bunch of these questions.
This is another gray area. We have the association's emergency powers, which is statute 718, 1265, I believe. And, as of right now, like I said, it is a gray area, but the state is not sanctioning associations that choose to use these so-called emergency powers. What I advocate is for associations to hold the meetings and to hold the election, but do it in a safe way, whether that's investing in electronic voting software, that the unit owners then have to approve, or that's doing it via Zoom. I definitely advocate doing it via Zoom. I think that's the safest way to do it. If you want to have people present, that is your right and your association. And if you can do it safely, perhaps outside and socially distanced, more power to you. But I believe that holding the meetings and the elections via Zoom is the safest and most transparent way during the age of COVID. Of course, make sure that you're giving people the opportunity to be heard. That is statutory. Perhaps at some point during the meeting, you can set aside time for unit owners that they can unmute themselves, or you can unmute them so they can be heard with regard to the agenda items.
Question we get here quite often is the application of maintenance fees. I call these assessment monies. There are all sorts of different terms in the documents, whether it's assessments or maintenance fees, membership fees due. If you have an owner who has incurred an expense on the part of the association for repairs to their property they're responsible for, can the association apply the maintenance fees first to that before applying it to the amount due for the month or the quarter, whatever the period might be?
Possibly. I would probably need more information on that. And I'd want to see what's in the governing docs, but the money needs to be used for what it is supposed to be used for, first and foremost.
Another question we get is also special assessments.
Mm-hmm.
Quite often, I'm sure you do too. This, again, probably goes back to the documents, but normally the board is empowered to adopt special assessments without membership input, but you have to have the meeting properly noticed and all that. Can you kind of comment on that process to clarify that, how that's done? Obviously.
Sure. So many people are surprised when they join a condominium association and they buy a condo that the board usually has complete authority to pass special assessments. And, a week after you own your unit or a year, you could all of a sudden have a massive special assessment against your unit that you are required to pay. And if you don't, could become a lien on your unit. It is a unfortunate fact of living in a condominium or any community association, really. There are statutes a statute that covers special assessments and the type of noticing that must be given. You must, at the board meeting where the board will vote, you must let the unit owners know that a special assessment will be discussed and voted on so that people can show up and, be heard with regard to that agenda item. It is a very controversial topic, and it's resulted in, many unfortunate situations where people end up having to sell their units because they can't afford the special assessment. It's very common.
One question I was going to ask earlier, for slipped my mind, is there a fee for using your services or the services of the Office of the Ombudsman?
Yeah, thanks for that question. So for me, there's no fee. I'm a government employee. I was appointed by the governor in July of 2020. The office is a completely free resource. For the election monitoring, there is a cost associated with having a monitor. It is a sliding scale based on how many units are in your condominium. And the process for obtaining a monitor, I'll just say very briefly, is a petition to my office with either 15% of unit owner signatures or 6 unit owner signatures, whichever is greater, be that 15% or 6. You send the petition to my office. We can provide you with the official form of the petition. We then go through a validation process and make sure that it is a sufficiently signed petition. And then we appoint a monitor at random to come and conduct your condo election. And like I said, that's a sliding scale of cost that the association is legally required to pay. And it's anywhere from $250 to $1,200 or $1,300 for the larger associations is what I've seen.
Kind of summarizing that, we're asking several different ways. If you have a new board member, what resources do you think are available, most beneficial for them, and working with the board and performing their duties and responsibilities as they should? So it's about those kind of resources.
The first thing I would tell a new board member is to take the board member certification course, which is offered through various institutions throughout the state. And also the DBPR, the Division of Condos, Timeshares, and Mobile Homes, does offer it for free. You can go online to the website and they have a calendar of when they offer it. There's also a whole list of other educational courses that would be very useful for new board members or any board member, really. So in addition to taking the board member certification class, I would say read your documents from cover to cover. Make sure you know what you're supposed to do and what you're allowed to do and what the rules are in your association. I would say read as much of 718 as you can bear if you're not an attorney. And I would say listen to the manager. Get a good manager, first of all, from a reputable company. Listen to that manager and get a good attorney that's a reputable condo law attorney, and listen to that attorney also, because the last thing you want to be doing is taking actions which are going to expose you to liability or sanctioning from the government.
Another question that kind of summarizing several here relating to the election monitor position. Mm-hmm. How to become an election monitor? Is there a training program? And what commitment do they have to make to serve as a monitor?
Sure. So that's a great question. Previous to myself joining the office, I believe at times there were training curriculums, and I think from what I've seen, they were a little lacking. Our election monitors are great, however, but I do have some ideas as far as uniformity that I want to bring into the election monitor program. And I'm currently working on a new training curriculum. It will be probably half a day to a day. And I'm looking for new qualified people that would like to become election monitors. It's an independent contractor position with the office. We don't take any cut of the fee. It goes directly to the election monitor from the association. And what I would say is that if you're an experienced CAM or an experienced attorney, especially a board certified condo law attorney, feel free to email me if you're interested in becoming an election monitor. I think it's a really great program. It's a great resource. It's a great way of giving back. It's a great way to help condo owners. And also, for people that are in business, you can get your name out there perhaps. But I'm really focused on building up this program so that we can make sure all the elections throughout the state are done correctly the first time go around.
One other question, I'm kind of combining several questions together, was related to how to handle delinquent accounts because of COVID-related issues, loss of income, illnesses, or are there any any provisions that protect the owners from having a lien filed or anything like that? Or do we envision anything like that?
At this point, we have the moratorium on evictions. It's going to be very interesting to see how that plays out. I've heard people talking about a potential bailout situation. I don't know what's going to happen. It is a hot topic, as you know. But for the associations, I would say, have sympathy and speak with your attorney to see what can be done and what you need to do. And, just remember that everyone is struggling right now.
Also, I've heard discussions, I don't know where you have or not, there has been some proposals floating to legislate processes for holding virtual meetings in this coming session. I don't know if you're aware of anything that might be something to give everybody a heads up about. I know everybody's been scrambling and operating under the emergency order we talked about earlier. But I know from our perspective as an educator and people that I deal with, we would like some more guidance from the statute on what we can and can't do. We've got the corporate law that says the board can adopt a resolution authorizing virtual meetings and those kind of things. But can you speak on that a little bit, where we are?
Sure. Well, we already have in the statute the regulations around electronic voting. And I do agree there needs to be something in there to talk about virtual meetings as a whole, because everyone is kind of operating in the dark right now. And I think until these cases go to court where judges can interpret the law and hand down legal holdings, Because again, that's not the place of the division of condos, right? That needs to happen from the judicial branch. Until that happens, we are kind of operating in the dark. And I'm hoping that, that we will get some legislation this year that will clarify these things and perhaps move us in the direction of being able to have virtual meetings, knowing that we're doing so legally.
Another question we get is, and this speaks to the corporate powers, I think, more than to the statute, but the board empowered to borrow money on behalf of the corporation, the condominium association, and obligate the association to pay that money back.
Yeah, I would say yes.
That comes under the corporate powers, I think, board powers, and as long as it's not prohibited in the documents. Can you speak to the, real quickly to, I'm not sure whether it's your area of expertise, but to the need and necessity for having a community association manager managing a condominium association? What are the standards? What's the threshold requirements? And not addressing the licensing part, but the requirements on the association part as well.
Sure. So associations don't have to have a CAM. I think it's a great thing to have a CAM. You know, sometimes if it's a very small association and they don't have enough income in the budget for a professional manager full-time, I understand that. But generally speaking, I think community association managers provide a great service, and they're absolutely essential to the running of an association, because at the end of the day, you have to remember that condominiums are corporations. And I often see boards full of very intelligent people, but people that either don't have experience running a community or don't have business experience. And in these situations, I think relying on the advice of a professional licensed manager is absolutely essential.
Can you address the issue of board communications contact? We hear sometimes the board members don't want to talk to the owners for what various reasons, or to some specific owners. Can you kind of expand on that and what your thoughts are?
Yeah, you know, it's a tough one, because there are associations with unit owners that just will never be satisfied and just want to pester the board members nonstop. And I get that. At the same time, the board should be as transparent as possible. So I'm not saying that as a board member, you need to stop in the hallway and explain your actions every time you see a unit owner that wants to ask, but you know, make sure that this person is having their opportunity to be heard, and make sure that you're educating everyone on the issues in the association and the decisions that are being made and why the board is making those decisions. And what I see is the more transparency that there is in an association, the less problems you're going to have.
We're going to look at several questions about use rights in condominiums. How far can the board go, the process for the board adopting rules? How far can they go in addressing use rights in a condominium through a board rule, rather than going through the amendment process to either the declaration or the bylaws?
Yeah, that's going to be a fact-specific issue, and it's going to be one that depends on that association's governing documents. It would just be impossible for me to give bright line answers to that question. So it is one that is going to require a legal and factual analysis, definitely.
One question that we got here is, and I'll answer it first of all. We had a question about the 8-year term limit language in the Condominium Act. The question was, does it apply to HOAs or co-ops? And it does not. Has there been any determination by the division with regard to whether that is retroactive or proactive, and the accumulating the 8 consecutive years of service before that kicks in?
Right. Listen, I'm happy to go on the record with this. The division's official stance is that this law cannot be applied retroactively. And this is the consensus of constitutional lawyers and legal minds within and without, or external of the division, I should say, that this law should not be applied retroactively, which means that it is effectively unenforceable in 2026.
So what happened, we started that within 2018.
Mm-hmm.
Years start there, so we won't have any impact of this until 2026. And at
Right.
either that time, the board members with 6 years of service can still run. And if they get 2/3 of the vote cast, they can be elected again.
Mm-hmm.
That's that process. And also, just as I said, to repeat, this does not apply to cooperatives or HOAs. It's condominium only.
Yeah.
As far as
Yeah. I get the question every day, and every time I give the answer, someone's upset. And you know, listen, to anyone listening, you're welcome to challenge this. And I think that if it goes to court and a judge, passes down an order and we have some bright line rule there, that would be a great thing. But at this point, the division has taken the stance that it is not going to apply this law retroactively.
I'm glad to hear that as well. Also, I'll mention that in last year's legislative session, there was a PIP package, community association bill that did explicitly say that it only applied proactively after July 1, 2018. That bill did not pass because of other complications. And I presume that's going to come back up in some sort of bill this session as well. And to get clarification and also to substantiate what the division's position is in that regard. Can you kind of walk through or give an example of how your office interacts with a condominium, an inquiry or a request for your intervention, answering questions, maybe an example of some things you might run into?
Sure. So, anyone is free to call my office or email me, and we'll make sure that everyone here has that contact information. You can, like I said, email or call, and we'll get back to you ASAP. Types of issues that we see, as you know, Fred, condo law intersects with so many different areas of law. In condominiums, you have real estate issues, you have criminal law issues, obviously condo law issues. I see everything from sexual harassment to stalking to material alteration issues. And I'll even say this, I was dealing with an embezzlement issue yesterday. I had a meeting with a mayor in a small town down here in South Florida, a relatively small town, and the police chief regarding an embezzlement issue. I'm happy to share these stories if you want. I don't want to take up all the time. You just let me know if you want me to get into these stories.
You please do. I think people hear more about what you see.
Sure.
And I'd just like to say, hopefully this will make you much more visible and people will utilize your services much more as well. Because I know in the past, I've always referred people to the ombudsman's office when they had questions or concerns. Mm-hmm. I'm not sure the response they wanted.
So this one was kind of a funny, interesting case. And a couple of weeks ago, an attorney reached out to me saying that he has represented an association down here in South Florida for about 8 months, and he has put together a full packet of evidence that completely proves that the former board was embezzling money. He worked with an accounting firm and did a forensic audit, and the new board, wants the former board prosecuted, and they may even file a suit civilly against the former board. So I said, listen, I'm happy to work with you, but I just want to let you know, and for everyone listening, I don't handle criminal law issues, right? These are things that have to go to law enforcement and our prosecutors. So I said, have you contacted law enforcement? And he said, I did, but they won't look at it. I said, well, remind me how much money was embezzled that you can prove? He said, we can prove $100,000 was embezzled. So I said, I can't, why doesn't the law enforcement want to investigate this? He said, well, they told me that it was a conflict of interest for them to investigate this embezzlement case because the association in question had in fact donated to their annual fundraiser before. I said, you've got to be kidding me. That is the most ridiculous thing. So you're telling me if I donate money to the Miami-Dade Police Department and then I shoot someone, they're not going to investigate me? This is ridiculous. This is the most ridiculous things I've ever heard. So I said, listen, they're going to have to tell me that to my face, right? If that's their position, they're going to have to tell me that to my face. So I called the mayor. Spoke to her. I called the police chief, and then I was able to get into the city hall and the police department yesterday. I invited the attorney to bring his complete packet of evidence. We walked the officers through the entire situation and all the facts, and they decided to open the case. So I'm very confident there will be arrests made in the coming months. And it is sometimes tough to get law enforcement to look at issues in condos, unfortunately, but it is absolutely necessary. And it's corruption and embezzlement and fraud in condos is unfortunately a widespread problem throughout the state.
And we saw that a couple of years ago, 3 years ago, manifest itself in large amounts of money. Can you speak briefly to the relationship of your office versus the regulation of the community association managers, and whether you have any guidance for boards in dealing with managers? I know you talked about you always recommend a manager. Sometimes it's not financially feasible, but and at what point does an association need to decide that they want to file a complaint against a manager for what they perceive as wrongdoing as well?
Sure. So the DBPR does regulate community association managers. There are professional standards of conduct that are laid out in statute, and also with the contract that will be signed between the manager and the association in question. If you as an association feel that your manager has either performed negligently or intentionally in a wrong way that has caused damage or done something improper in the association, I would advise that association to file a complaint with the DBPR. You can email me. I'll get you a standardized form to do so. And all the instructions are there. We can talk about what would be needed to file that complaint. But when you do file a complaint against a licensed manager, there is an investigation that will happen. There can be witnesses being interviewed. There will then be, up in Tallahassee, attorneys that look at all the facts and decide whether or not there's sufficient evidence to move forward and potentially sanction the manager. Very rarely we see managers losing their license. Usually when it's related to a financial crime, we'll see a manager completely losing his or her license. Usually it would come in form of a sanction or other disciplinary action, but there is a process in place for this, and it is with the DBPR. My office is administratively located in the DBPR, but I'll mention that I don't handle those complaints. I don't have the power to investigate issues or sanction managers or associations, but I can be a liaison for you in that respect.
Generally speaking, the concept of material modifications or substantial additions for condominiums, we have that 75% threshold if the documents are signed. The biggest question we get is what constitutes a material alteration or substantial addition? I know there's no clear answer to that, but right. I'd like to hear it too. Sure. So another tough question. As you said, if the documents are silent, you have to get a 75% unit owner vote before you move forward with a material alteration. You, as your association, should definitely consult with your attorney as to whether or not the proposed action could be considered a material alteration or not. And I wanted to mention that your documents can change that 75% requirement if it's in the documents. You can do that. But back to what I was getting at, I would definitely utilize the attorney's advice when you're considering something that could be a material alteration, because you could be opening yourself up to liability and the association could be sued. Right? And that's never a good thing, to get involved with litigation between the association and unit owners if it can be avoided. What I'll say about this, people email me and call me all the time saying, we want to change the color of the carpets. We want to build this. We want to repurpose this. Is that a material alteration? Unfortunately, it's not a call that I'm able to make. It requires an arbitrator, really, to look at all the facts and hear legal arguments from both sides before handing down that legal verdict. It's not something that I can do over the phone. It's not something that
and it's not something I could do in general. I don't have the authority to do that, but it requires a sufficient, amount of due diligence in terms of a legal and factual analysis to determine if something is a material alteration or not.
Quick question. It's regarding the election process in condominiums, where we have what we call the first notice of election going out 60 days in advance, the 40-day cutoff, 35 days for the candidate information sheet. Can the board arbitrarily change those dates? Make it, instead of 60 days out, mail it 90 days out. Also, can they change the cutoff date? Instead of 45 days, can they make it, again, 60 days? So can you speak to that a little bit?
So what I would say is, the statute needs to be followed. Can the association increase the amount of days? But possibly, but I would say you should just mimic the statute to be safe. Because if you enact a rule like that, it's challengeable. I would have to review some case law on that specific issue, but I would say that to be perfectly safe, you should mimic the statute, which is what I see pretty much in every situation.
I got one question going back to meetings again, and it's one that I've received several times. What is there any impact if an association just decides not to hold an annual meeting? And how do they move forward from that? Again, dealing with the COVID issue and the times we're in right now.
Right. So it's a difficult situation. And earlier I referenced the association's emergency powers, 718-1265. In the included emergency powers, there is the ability to cancel and reschedule any association meeting. So some associations have canceled the elections and meetings. I wouldn't advise it, but I don't know that you'll necessarily be sanctioned if that does happen in your association. At this point, you probably wouldn't be sanctioned, but I would advise that you need to have the election, and in the name of being transparent and making the unit owners feel heard, do the election, have the annual meeting, but do it virtually, do it safely. And, the associations that I see canceling it usually are doing it with malintent, in my opinion. It's because they want to stay in power. So I think that associations can do it safely. Look at us right now, right? We're having a meeting virtually. It's very possible. So that's what I would advise associations to do.
Thank you. Is there any process whereby the board or the documents can be amended to limit the number of rental units in a condominium association, either short-term or long-term rentals?
Sure. So associations are free to enact rules around the rental regulations in their association. It's not something that the state prohibits them from doing. There is a legal issue of being grandfathered into an old rule on leasing that you probably should be aware of if you're doing this. But overall, this is something that the association should do with the consultation and advice of legal counsel, so that they know definitely what is required based on those specific governing documents to enact such a rule.
I'm not sure your office is running into this, but I'm not sure that you're involved in making any decisions about this. But do you have any comments or feelings about the emotional support animal issue? And we all say that with a smile.
Yeah, I don't have a stance on that. The law needs to be followed. People's rights shouldn't be infringed. I know it's a problematic issue. It's a hot topic, but I don't really have much to say about the emotional support animal issue.
The question we get quite often is, why is the department apparently so lenient when they do find violations of boards, owners, whatever, in complying with the Condominium Act. And I'm sure the word lenient is not the word that we would like to use, but so one question, so why aren't they more aggressive in pursuing the wrongdoings?
Well, I think some people would say they're too aggressive, honestly. Just depends on which way you look at it. I think that they do a good job. I think that we have to remember that these positions, the board member positions, are volunteer positions that are not paid and usually require a substantial amount of hours and work. So, we need to balance all of these factors. And I think that the division does a great job when it comes to working with associations and trying to get issues resolved. I do see associations being sanctioned, but if the association can remedy the problem quickly, then I don't necessarily see the need for a sanction if there's no harm, no foul. And then, of course, we're in different territory if we're talking about an intentional crime like embezzlement or fraud. That's a different world. But I think we have to balance all those factors, and I think the division is doing a pretty good job at that. And I'll also say we have a new director at the division, and I'm very excited for him. I'm not sure if it's been officially announced yet, but he seems to be a great guy, and he is very intelligent and already has a list of items that he wants to change and improve in the division. So I'm very excited about the future for the division.
Great. Another question, I had several to ask, but I'm going to try to summarize it. Does your office have any authority or ability to investigate or sanction community association managers? I think you touched on that earlier, but I wanted to clarify that.
No, I don't have the authority to sanction managers or associations. I work with the division, and if I uncover, a civil infraction of 718, then what I can do is recommend enforcement action to the division for the division to take. This is something that I don't think any ombudsman has ever done, to be frank. And I'm the first one that is working with the division, and we have a great relationship to have that sort of communication and that ability to be connected from me here in South Florida and them in Tallahassee. So this sort of thing will be happening. It's going to come in form of an official recommendation to the division to pursue an enforcement action.
Good, thank you. I'm excited to hear that moving forward. And I'm excited about the new director as well.
As am I.
One question we get, and this is something I think was come from a practical standpoint, how can owners be more proactive and active in working with the board to get policy making? Does, for example, the board have to entertain a suggestion from the members with regard to changes in rules or things like that, or the structure of how the board functions a little bit? If you could do that and speak on that as well.
Well, you can't force the board to act a certain way, but you do have the right to attend all the meetings, and you have the right to be heard with respect to all the agenda items. So I would say get involved in your association, go to the meetings, but do it civilly, don't attack anyone. Remember that these board positions are difficult because you're never going to get 100% of people to agree on any course of action, right? There's always going to be dissent. And, we hope that these associations are run like democracies, right? So, be heard, run for the board, attend the meetings, get involved, but do it in a civil way.
I have a question both on the chat room, or Q&A session, and also that we received. Can you speak to the use of a voter certificate, voting certificate in a condominium, multiple owners? Does that have to be done every year, or is it permanent until filed or changed? Can you talk with that for a moment?
Sure. So this is something we deal with a lot in my office. Voting certificates are not created via statute. It is something that your association is responsible to enact rules around if it chooses to do so. And for people that are listening that maybe aren't familiar with voting certificates, when you have a unit that's owned by a corporation or multiple people, you need to know who is authorized to vote on behalf of that unit. And the way that we do this is with a voting certificate, which is going to be signed by all of the people that own the unit, or the relevant people in the corporation. And it's going to appoint one person that's authorized to vote on this unit. Now, as I said, the rules around this will be located in your governing documents or on the voting certificate itself. So I would definitely examine both of those for more information. But it is a topic that we deal with every day. The association should keep these on file forever, right? You should not have to file a new voting certificate every year. It should be included with the ballot, however, but it should be on file with the association indefinitely.
I know there's a procedural, and you may not be able to reflect on this, but if an owner mails a payment in, their assessment payment, maintenance fees, dues, whatever they want to call it, is it considered received on the date of postmark, or is it considered received when they receive it in the office, or is it considered received when the funds are deposited into the association accounts? That question comes up with regard to late fees.
Sure. Yeah, honestly, this is not really something that I get too involved with. When I do have these issues, I call the association and try to work out a solution so that it doesn't have to go to litigation or anything like that. In my mind, and I would have to do some more research to be frank with you on this. In my mind, it should be received when the association actually receives it. But that answer could change depending on some case law research. But it's really a transactional real estate issue. The associations, I would ask to have a little bit of compassion in these situations.
I get a question about mold, and I'm not sure you can address this. If there's a mold is found in the walls of a unit because moisture, whatever it might be, which party is responsible for that cost of mold remediation, or doing whatever is necessary to remove it and protect from it, also stopping the spread?
Sure. Again, this is going to be an issue that's definitely determined by your governing documents. It's going to depend on where the boundaries of your unit start and end. If it's in your unit, there's a good chance that it's the unit owner's responsibility. If it's not in your unit, it's a common element, it's going to be the association's responsibility, barring some very unique situations. But it will be an issue that is determined based on those specific governing documents in your association.
I know this is not probably in your area as well, but it's something we'll get asked a lot. What is the board's potential liability if someone blames them because they got COVID from another resident? And could they be liable for cost of medical expenses, damages, whatever else? That goes back to the sanitizing issue we talked about. And I know it may not be in your realm of
no, it's not. It's not something that I would handle. It would be a private lawsuit between that unit owner and the association, or potentially between that unit owner and the board member personally, if there's an allegation of a breach of fiduciary duty. That would take a very significant, extreme fact pattern for someone to allege a breach of fiduciary duty for that reason, in my mind. You can sue anyone for anything. Would you win? I tend to think not, if the board took reasonable precautions. But again, it's a factual and legal analysis based on that situation.
Does your office have any sort of communication protocol with residents of condominiums or managers or anything like that, sending out newsletters or updates? I'm not sure you have that in your budget process, but can you?
No, we don't have an official newsletter. I did just create social media pages for my office, though. Everyone listening, you're free to add it on Facebook, Office of the Florida Condominium Ombudsman. That was created, I think, a couple days ago, actually. So that's going to be a great resource just to follow the office if you're interested, and to follow condominium law and updates with condo law. So I'm excited about that. And I think at this point that will be our newsletter. It will just be social media. And again, you're free to follow me, add me on LinkedIn. I'll add you back. And I am always posting updates with condo law and things with my office as well. So I really am looking forward to using social media to connect with as broad of an audience as possible.
And I had a question come up again, and about virtual meetings.
Mm-hmm.
And the question was, do you have to follow the same notices, processes? How do you handle proxies in a virtual meeting? And obviously, the virtual membership meetings are not authorized virtually in the statute, but the corporate law says we can do that.
Mm-hmm.
But again, going back and repeating what the process would be, the 60-day notice, the 40-day cutoff, 14 days notice for the meeting as well, and how we handle proxies for those that can't come by Zoom or whatever the other virtual platform might be.
Absolutely. What I would say is literally do everything the exact same way that you've done it in the past, but let people know that the location of the meeting is going to be on Zoom. Make sure that you give all of the information that you would normally give about the physical address, but now you're giving the information about the virtual address. And an absolutely critical thing that I would recommend is not just the Zoom link with the URL and code or whatever, the meeting ID, but also make sure you're including the telephone number to call in on. Because as you know, we have many, many people, millions of condo owners throughout Florida that are not comfortable with Zoom. Perhaps, elderly aren't very computer literate, but these people have phones, right? They can call in. Worst case scenario, they can call in and listen to the meeting, listen to the election. And what I would say as far as running the election and running the meeting, you don't have to position the camera in such a way that you're going to be able to read the ballots, right? That's never going to be possible. But and you don't have to announce the names on every ballot as you go, but make sure that the camera is pointed at the ballots the whole time, and people, know the ballots aren't being taken away or thrown away. Make sure the camera is front and center, and people, just be transparent with it. Announce what you're doing when you're doing it. Be vocal for the people listening on the phone. Now I'm opening the first ballot. The voting is closed. Now we're reading this. Now we're verifying this. Now we're going to talk about this agenda item. Do it clearly. It's not that difficult. Most of it's common sense. But like I said before, just hold the meeting virtually the exact same way that you would do it physically.
Thank you for that. Again, question we got on the chat room. If this has to do with the use rights again, if you have a condominium where the documents say you cannot rent for less than a month or the 30 days at one time, and there's an owner that lets people come and stay for a week at the time, and they state that they're friends of the owner, so they're not saying they're renting from that, can the boards do anything to limit that activity?
Sure. So the boards do have authority, statutory authority to levy fines. Fines can, however, not become a lien on a unit. And there's, maximums that you can fine. I would also look to see in your governing documents what authority you have to sanction unit owners. Once unit owners are delinquent or non-compliant, you may be able to suspend their access to certain common element areas. These are things that should be done with consulting and advice from the attorney, of course. But there are remedies. You can't foreclose on the unit from a fine, like I said, but there are certain remedies available to boards, certainly.
One specific question we have, and I'm sure again it's a procedural question. At a board meeting, can the presiding officer, the president of the association board, whatever we want to call him, refuse to entertain a motion from one of the board members?
That's interesting. I would want to see in those governing documents what the procedure is for motioning. I would be tempted to think no. If that procedure has been met, maybe it needs to be seconded. I would be tempted to think no, but it would require me reviewing the procedure for that association to make motions and possibly what the topic is about.
We also get the same types of questions. Does the board have to entertain a call for a motion from a non-board member if the president doesn't want to address that issue?
Yeah, I would say no.
That's good. Well, can the board also create a position of an officer who is not a board member?
Yes.
We have a question.
And I'll follow that up by saying that the statute doesn't even require that a board member be a unit owner, which is kind of interesting. So your association may enact rules regulating who is allowed to be a board member, but the statute from Florida, 718, does not require that a board member be a unit owner, actually.
Yep. And that's usually found in the document somewhere, definition of board member. But that's a good question as well. The question, I'm trying to phrase the question we had on the Q&A here. When we talked about election monitors, it requires 15% of the owners or 16 owners or greater to petition for election monitor. Mm-hmm. Does that same process apply if you want to have a CPA come in and do monitor the election on behalf of the association?
A CPA? No, I don't have the authority to appoint a CPA. And I don't know of any part of the statute which would allow a unit owner to hire a CPA on behalf of the association either. What 718-5012 provides for is my authority to appoint an election monitor. And that's the only thing that I can do with regard to the election is someone that is an independent contractor from my office, such as Diana, as she mentioned before. She is an election monitor that we do appoint. These people are not CPAs. They're not doing any sort of financial investigation. They are simply there to conduct the election on the day of the election itself.
Do you have any comments or input? We'll get questions about how does Robert's Rules of Order parliamentary procedure impact membership meetings and or board meetings?
I think they're guidelines. I think they're good guidelines to follow. I'm not aware of any requirement to follow Robert's Rules of Order like a statute you would, but I think that they are useful.
It's usually addressed in the documents in there as well.
Sure.
The parliamentary procedure. And I always like to mention that parliamentary procedure, some of that doesn't apply to board meetings because of their small bodies. So much more informal meetings than the membership meetings as well.
Sure.
Fred, perhaps he could, perhaps you or Spencer could just discuss a little bit about the annual meeting via Zoom, since that will kind of relate maybe to elections for them and counting towards a quorum, that question.
Spencer can address it.
Yeah, sure. So we need to have 20% of people cast a ballot for a valid election. As far as quorum for the annual meeting, the division at this point has taken the stance that attending virtually does count as attending for purposes of the quorum. Now, we're getting into an area of statutory interpretation, which in my mind, in my opinion, really isn't the place of the division to do. That needs to come from the judicial branch. So the division is treading carefully on these issues and taking stances using, educated legal analysis based on what its power is in a situation. But before we need a judge to give bright line rules on these interpretations and these questions that have been brought up.
Could that also be addressed legislatively?
Yeah, absolutely.
I think that's the avenue we're trying to take right now.
Yeah.
You have the legislature spell out what the ground rules are for the virtual meetings, and the issue, if you're having a virtual meeting, if the person cannot attend virtually, then they could also submit a proxy as well. And that would count as being present. And of course, if you're voting on anything other than the election, you have to use a limited proxy for condominiums. But we had some discussions in our last roundtable about conducting the elections. Fortunately for condominiums and cooperatives, we have that process spelled out where it doesn't matter whether if you're at the meeting or not. That's a totally separate issue. It becomes a different issue when you're trying to determine, do we have a quorum at a membership meeting and take other action other than the election as far as condominiums are concerned.
Right.
And that's a whole different situation for HOAs because of their election process not being specifically spelled out in
Big
the
time.
statute. And, but
Yeah.
you said earlier, if you take the virtual meeting and treat it just like a regular meeting in person, with all the notices, everything done just like you would a virtual in-person meeting,
Yep.
I think you meet the requirements that we're living under right now. Do that. And Diana, did you have another one? Anything else I may have missed?
Yeah, there's one that if you wouldn't mind, Spencer and Fred, there's one of our participants who was a little confused or with the declaratory statement that Spencer mentioned about the term limits. And she said she was confused that she thought that the term limits, that the declaratory statement said that the 8 years was retroactive. So Spencer, would you just clarify that one more time?
Sure. Yeah, this was the Apollo case in which I believe an arbitrator held that it did apply retroactively. This position is inconsistent with the position that the division has taken. And I believe, and the division believes, and many constitutional attorneys believe that if it were to end up in court, a judge would rule that it is not to be applied retroactively. So this is the position that the division has taken, and it is confusing. There has been a lack of clarity around this issue, and it's such an important law that it comes up all the time. So all I can say is that that is the division stance. The division is not enforcing that law at this point. It's not sanctioning associations that don't follow the required 2/3 vote. And that's really all I can say.
When the board adopts rules regarding the right to speak at board meetings, do they have to have 14 days notice for the meetings where they're going to adopt those rules? And if they approve the rules, they have to be recorded with the clerk of the circuit court. And should the written opinions from the association attorney be part of the official records of the association?
I would err on the side of including things in the meeting minutes. If it's an attorney's opinion about proposed or active litigation, I don't think that it's part of the official records of the association in such a way that union owners would be entitled to view that. Certainly, when there's a board meeting with the attorney for purposes of obtaining legal counsel on those issues, it is not open to all unit owners. I'm trying to remember the first part of that question.
Does the board have to give any special notice for a board meeting where they're going to adopt the rules or procedures for owners to participate in board meetings? And the question was particularly, they have to give a 14-day notice for that type of board meeting.
I, off the top of my head, do not think that it requires special notification in the way that a special assessment would. Yeah, I don't think so. I don't think so.
And I would agree with that as well. And that part of the question. Let me see.
Fred and Spencer, I just want to let you know to be on time. We have 5 more minutes.
Okay.
So just so that you can say whatever you want to say as well. Thank you both. It's been awesome.
Thank you.
So far. Thank you.
Spencer?
Went by quick.
Okay. Well, I want to say thank you, Spencer, for joining us, and for the information you provided and the resources of the Ombudsman's office. And we look forward to working with you in the future and greatly appreciate your expanding this office to what I think it should be and serving the residents of condominiums throughout the state of Florida as well. And I want to say thank you to our participants participating in the program. We will try to answer any questions that we did not get answered here. We will also be making available to you the contact information that we have for Mr. Hennings in his office as well, and all of our contact information. Many of you already have that, but we'll make that available to you. So thank you. Have a great day, great week, and a great new year.
And thank you for having me on. I really do appreciate this opportunity. And anytime you want me to come on in the future, if there's a hot new topic, I'm happy to appear on the show. I really appreciate the invite. Thank you.
Thank you.